Okay. Well, I want to the next part really is just going to be quick, but it's so that you know where to find the information. So the first thing is people are flabbergasted, you know, with all these different courts, and again coming back to this question of what does the word jurisdiction mean, all right? So this here is the court structure. Kerry, come here. Is the court structure of the UK, right, from bottom to top. At the top is the Supreme Court, and that's the bottom. The Magistrates' Courts. In the Magistrates' Court, Part 1, it has criminal jurisdiction, and Part 2, civil jurisdiction. Okay? Now, the question of bias or independence of the court comes into question, because the Magistrates' Court Act says they can only have jurisdiction for what we tell them. Okay? So that's clear bias, and showing that the courts are not acting independent. And like I've been saying,
is your camera turned on?
Yeah, it's on. And so we should be bringing the matters, because guess what? As soon as there's a financial constraint, that's creating bias. It's in breach of equality. Now, we should all have equal access to the law, irrespective of our financial ability. Why? Because money actually has no value unless there's the rule of law. The rule of law is foundational for everything in a society. So it's beyond money. It's about principles of how we live in peace, because we're all entitled to peace. Why? Because nobody can prove authority to impose their will on any other. Therefore, the only conclusion is we all have the right to peace. And so everything really should start in the magistrates' courts. In Kuwait, the way that it's done is you've got a section of town or district, and every district has a magistrate, and the magistrate's on call 24/7. So whenever there's a dispute, anybody can go to the magistrate's court, the magistrate, and they'll look at the evidence and say, okay, let's see how we can sort this problem out, return to the peace, and if we can't, then I will direct you to the correct place to go. So that's the way it should go. So with all of this, we can use the legal fiction to our advantage again. All right? So the legal fiction is, who's the principal of all of this stuff? Lord Chancellor, Her Majesty's Courts and Tribunal Service. So it shouldn't matter, because we're not employed by them. So therefore, we should be able to drop our claim in anywhere, or our complaint, or lay our information anywhere. It's up to their internal structure to decide where it needs to go to. Okay, so if they've got a specialised office to deal with trusts, I drop it into the magistrate's court, you have to look at it and say, okay, this goes over there. This one's intellectual property, it goes over there. This one's family matters, it goes over there, etc. But what they're trying to do is say to us that if you want a remedy, you need to work all this crap out for yourself. And if you put it in the wrong department, the form of law, then, oh well, we're not giving you your money back that you paid. You've got to pay again and put in another application here or there or anywhere else. So when we look at the way that it works, again, thanks to Calvin, we've got evidence. It's equity over substance. So what the court did was, and Calvin quite correctly pointed out to the court, I have a contract with you. I've paid you my money, and I expect you to stick by the contract. And the contract says, this is the rules of the game. Okay? You've got to give me due process. And so they were complaining because an appeal went in against their decision to set all these cases aside. And basically the question became, well, mate, I've put in an appeal. But you haven't put it on an N244, the form. And so it was simple. I put in an appeal, that's the substance. I have an issue with your order. And I can't remember, was it a day
I
late
just
or
called it a
something?
letter of objection.
Letter of objection it was called, okay? And was it a day or two late or something like that? I can't remember.
No, I sent it to the money claims department, he said I didn't send it to the correct court.
Yeah, okay,
Yeah.
so the internal process
Yeah.
doesn't really matter. So this principle of put it in their system, it's up to them to sort out where it goes. And then, because they hadn't followed the due process. Now, when I was talking about the notices earlier, and how this links back to breach of peace is really simple, okay? Honour, good faith, clean hands. If I believe you breaching my peace, I put you with the knowledge of that breach of peace. And I need to act in honour. What that means is I need to give you a reasonable chance of time to correct your behaviour. Therefore, the notices generally are, you know, a breach of peace, or whatever you want to call it, opportunity to remedy. You need to put in your notice what remedy you want to return to peace. So I need to give you a reasonable amount of time. If you still don't react, I send you the second notice. I give you a reasonable amount of time. If you still don't react, I give you the final notice, or letter before action, give you a reasonable amount of time. And if you still don't settle, guess what? We're all equal kings and queens. We've not managed to settle this matter in private. I make my default judgment as a king, and I take that default judgment now as my claim into public dispute resolution. And the system works exactly the same. So, somebody brings a claim into the court. If you don't respond, just like if somebody puts on their envelope, return to sender, or whatever, or not known at this address because it's written in capital letters as opposed to small letters, or whatever, exactly the same process applies. We have an obligation to keep the peace. And if we do not respond to another person's belief, which is creating a belief of a breach of peace, we are acting in dishonour. Therefore, by us, you know, return to sender, or no, my name's not written like this, it's written like that, or this sort of nonsense, you will end up with a default judgment. Okay? Same thing happens in the courts. So what's happened is we've tried to settle in private, we've been dishonoured, disrespected, our peace has been breached on. If I have an honest belief, I have a lawful excuse to breach your peace and put my claim in against you, be it a council tax bill or whatever it is, and you don't respond, you are therefore breaching my peace now. Because your obligation is to keep the peace. So you must respond to anybody's claim.
Sorry,
Yeah.
even if it's unlawful.
Even if it's unlawful. Because it's their belief. We all have different socially conditioned belief systems. It's true to you, or what's true to you may not be true to me. May not be true to a reasonable person, but it's still your belief. Okay? I have an obligation to you and everybody else to keep the peace. Okay? So, same thing happens with public dispute resolution. Somebody puts in a claim, the process is always the same. You need to serve the claim. Because without notice, without evidence that I've been put with the knowledge, how the hell can I keep the peace? If I don't know what your problem is, and you've not told me what your problem is, I go, what the hell do you want me to do? I'm not a mind reader. Okay, so service of the documents is critical. And the way that it used to be is when you submit it to the court, they stamp, give it a number, you photocopy that front page and you put it together with all your same documents that you put into the court, and you have to serve it on all parties. Why? So that everybody is on the same page as to what the problem is. So, it's moving very much to electronic, i.e. we're incorporating technology. So the money claims is a brilliant thing. Okay? Why? Because it's automated. It's pre-programmed. It only has problems when people start to bugger around with it. So you can go online, you can put in your claim, and then it goes through, they give it a number, and it gets emailed out to whoever you said is the respondent. The court serves it, and then the due process of law continues. Now that you, with the knowledge that somebody believes you've breached their peace, these are the details, the particulars of the claim, i.e. the supporting reason, the lawful excuse to breach your peace. Now, you've got a choice to make once the claim's been served on you. Do I ignore it? Or it tells you, hang on, no, you must acknowledge service. So if I acknowledge service,
Just
yeah,
one point there, Mark. What you be careful as well, when you put a claim on someone and they fill in one of these N9s, it can be a defence plus a counter.
oh yeah.
So you now become the defendant,
Yeah.
and you have to defend that first.
Yeah. Okay, so basically, once you've received the documents, to show that you're upholding your obligations to keep the peace, you're saying to the court, yeah mate, I've been served this document, thank you. And they give you 14 days to acknowledge service, and a further 14 days to file your defence, or any other documents. So you've got 28 days to respond. If you don't respond, what have you done? Now you've dishonoured the public dispute resolution system, which is trying to return the arguing kids to peace. And therefore, he who asks, put in the claim, gets what they asked for. And you end up with a default judgment against you. Okay? So if you do not engage, sooner or later, you're going to end up with all these default judgments against you. And then that's when the bailiffs start to get involved, and all further enforcement and all of this nonsense. So the easiest way to stop all this nonsense is simply respond in honour, good faith and clean hands. So you can put in a defence, and there's this thing called civil procedure rules and criminal procedure rules. Fundamentally, it's really simple. Okay? The details may become a bit more problematic because there's certain specific procedures for certain specific actions. Okay? Intellectual property law, there's specific stuff relating to it. So therefore, they have specifics for that. For money claims, there's specific things for that. For trespass claims, there's specific things. So it's rational that you do have some specificity, whatever the right word is.
Sorry, Mark. So, where they send you something,
Yeah.
and a simple response be, who is making the claim against me?
And, okay, when you make a claim, and basically once I sort of get the structure and or flow of information, I want to get on to basically showing people how to prepare claims and prepare defences. Simple, I'm not going into massive detail with it. So basically, who did what, where, when, what was the harm, and what you wanted remedy. That needs to be there. If you don't identify who harmed you, who are you claiming against?
So in the instance, for example, like those PCNs or you've gone in the bus lane and it says...
Who's the harmed party?
Hammersmith and Fulham believes.
Well, when you look at all of these things, they're making an allegation. Okay, some of the fines are so obvious, they even say offer of fine in their header.
Yeah.
It's an offer. Okay? But that there does not create an obligation on you. So this all comes back to what we've looked at so far. There must be joinder between the claimant and the defendant. There must be something which creates the duties, rights and obligations between the respective parties. If there's no joinder, what's it got to do with me?
So then don't answer it that way, because you're saying that we have to answer.
If you don't answer back, okay, Hammersmith Council or whatever it is, they have the honest belief that they have the right to send you a PCN, you know, whatever, fine or whatever. Okay? If you don't respond, then because a legal fiction is given the rights to sue and be sued, that's the way that, you know, legal fictions work. That's the only relationship, the only same thing they have to us humans, is the right to sue and be sued. They can't sue. Why? Rationally. Because they can't be harmed. So it's insane, the concept, to give a legal fiction the right to sue. Okay? But, so basically, everything, because it comes down to a breach of peace, is harm. How can a legal fiction be harmed? I don't get it yet. I haven't worked that one out yet. I don't see how a fiction can be harmed. It doesn't exist. It's not a thing. It can't be harmed. It can't cause harm. Okay? And it can't act. So nothing that it does can be unlawful, or anything done in its name can't be.
Don't they call it a victimless crime, though?
Yeah, victimless crime. Well, it's utter nonsense, victimless crime. If there's no victim, okay, because we are the
Well,
principal.
they do say it, though. I mean,
Oh no, it's shitloads, it's masses of it. Okay, but we the people, okay, it always needs to be a harm party. We're the source of the authority. Okay? So this thing here, or somebody that's not been harmed, how the hell can they rationally bring the claim? They can't, it's stupid. The whole concept is moronic. So, but it's because of this belief and the way the system is at the moment, okay, they can sue you as if they are a harm party. Their belief is legislation is law, and under some piece of legislation, they'll quote you the section and all of this stuff that gives them the belief that they have the right and that you have the obligation to pay them. Okay? So, quite simply, the same thing what we're doing with the council tax. Prove my obligation. Prove my joinder. Prove that 650 MPs, okay, can knowingly breach their authority as defined in the Bill of Rights to do something to my prejudice. It's an insane thing, okay? So exactly the same concept applies to fines, to PCNs, to 5G, to you name it. It's the same concept.
What about individuals? So say I've got a property
Yeah?
and I, well, you know, own the property, and you decide you want to come park on my property, and you block me from leaving my house or whatever, or even if you just park, you just decide you want to park on my driveway, and you walk away and you come back and take your car in. What can I do about it? In terms of that, I know it's a civil claim, but what can I do? You haven't really harmed me, you haven't done anything, you just parked on my property.
Yeah. So if you've not been harmed, what's the problem?
But if I've been inconvenienced, then that's a slightly different one, isn't it? Because then
Is it
ultimately I can claim
inconvenience, not
loss.
harm?
No, but if, like, for instance, if they block my car in and I can't go to work,
What's the difference?
That's harm.
Trespass
They've
on the property
harmed you.
technically is harm, isn't it?
Because they've denied you your right to be able to have free access and enjoyment for whatever your property.
Denying you your right to park there.
So-
Isn't it?
Okay, so what happens then is, after 28 days, because you've been given reasonable chance to engage and resolve this dispute, including if you feel that they have no lawful excuse to have breached your peace with their claim, you can put in a counterclaim against them. Okay? Now, the way these things work is, you have a claim. As soon as you have a counterclaim, or an application to strike out, or an application for disclosure, or an application for anything. Now in America they call them motions, okay? Here they call them applications. So in America they'll say a motion to dismiss. Here they call it an application to strike out, same thing. Okay? What happens is, all of these things need to be settled first before you can come back to settle the claim. Okay? So, after 28 days, if you do not engage, you can, the claimant can apply for a summary judgment. So with council tax, let's have a look how this happens. The council has a belief it has a right to send you a bill. And they quote local government, council tax admin and enforcement regulations 92, section whatever. And according to those regulations, it says the property must be on the valuation list. They must send you a bill, their claim. If you don't pay, they must send you a reminder. And if you don't pay, they have the right to apply for a summons, so long as it's 14 days before the hearing. Okay? That's their belief. So when they send the council tax bill to me, I have a choice. I can throw it away, I can do this, I can return to sender, I can do what the hell I like. No difference if it's a gas bill, electric bill, any bill, a bill from Dwayne, anything. Okay, it's my choice how I react to it. However, if I do not uphold my obligation to other people, okay, I am breaching their peace. As a result of that, I will end up with a default judgment if they take it through the courts and I do not engage. So, not to engage is the most absurd notion that people preach. Yeah, Nick?
I'm going to ask you an embarrassing question, Mark.
Go ahead.
I have to ask. Driving a car down the road
Yeah,
with defective brakes,
yeah,
knowingly,
yeah.
without having hit anybody, is a crime.
Sorry, and not hit anybody.
Having not hit anybody,
Yeah.
the act of driving a car with defective brakes knowingly down the road is a crime.
Is it really?
It absolutely is.
Why?
Because in the duty of care, you must take care to avoid actual emissions of life.
Well, you did, by the sheer evidence that you've not caused harm.
So you're
It
saying
was
everybody can go
sufficiently
around, so
safe.
you're saying everybody can go around driving with defective brakes, it doesn't matter. Eventually someone's going to get harmed, and that will.
Somebody might get harmed.
They will.
No, they might. What you've expressed, Nick, was I got from point A to point
The
B.
duty of care, Mark, is the fundamental.
Hang on. Okay, and we'll talk about, I'll answer that. The fact is, whatever condition your car was in, you got from point A to point B without causing harm. Okay? What you're talking about is potential harm.
Yeah.
Okay? A big difference.
Foreseeable likelihood of harm.
Most of the vehicles in Sri Lanka have got defective brakes and they don't crash.
Well, okay, it's even more fundamental. Just because I've got an MOT certificate today
I didn't say
doesn't mean
I know.
tomorrow
It says-
my brakes are going
it says
to
on the certificate, it doesn't.
okay.
Mechanical.
So,
I didn't
you
say
saying
driving
be. If
without-
I know,
I didn't say driving without an MOT. I
you were
said driving
saying
defective
with the knowledge of defective brakes.
That's what I said.
Okay? Now, it depends on how defective are they. I got from A to B safely, I might have travelled at 1 mile per hour,
So it
therefore I
depends on
followed
the
my due
defective brakes,
diligence.
and there are circumstances where it's unlawful to do it.
Yeah, but hold on a minute, I've had
But you've
brakes done.
said no harm was caused.
I said no harm was caused.
Correct. Therefore,
It's no crime.
there's no crime, there's no problem.
It's not true, it's not true.
Shouldn't it go back to his conscience for getting into the car if he knew?
If I was driving with a car with defective brakes, where the brakes zero didn't work, okay, and I was driving at 1 mile an hour with all my lights flashing, I followed my due diligence. I've safely followed my
Nick,
duty
are you
of
saying
care.
if you drive along and suddenly your brakes start squealing, you've got to pull over and stop and can't drive any further, any
Are
forward?
you
That's
talking
it.
about law or legislation?
I'm talking about the duty of care, which is law.
Law,
Yeah, we have a duty of care not to knowingly cause harm.
another.
No, it doesn't say cause harm, it says it says, quote, it says you must take reasonable care to avoid acts or omissions
Which is duty of
which
care.
you can reasonably foresee would be likely to injure your neighbour.
Right, so if I'm driving at 1 mile an hour because I know I've got defective brakes, what's wrong with
So
that?
what if you're driving at normal speed and you know you've got defective brakes?
But he's not though.
That's not duty of care.
You know,
It is the duty of care.
No, that's not, he's not taking.
that there's very
That's-
specific, okay? But
It's
in
not, it's general.
essence,
It's absolutely general, it's the general.
it's
case.
absolutely general, you're saying, but if I'm driving at 1 mile an hour because I know I've got defective brakes,
Well, he is.
okay, then it's perfectly fine what I'm doing.
Yes, but
If I'm driving at 100 miles an hour knowing I haven't got brakes, that's a very different
That is
situation.
the circumstance I'm talking about.
Hmm?
That is the circumstance I'm talking about. Driving a car down the road as normal.
Only-
knowing-
only-
Yeah, okay, and so let's go back.
Only a fool would do that.
So let's go back to the basics. If I've caused no harm, because I did this at midnight and there was nobody around, what's the issue?
It doesn't say no harm. The law says reasonable, foreseeable likelihood.
And equity says if I've caused you no harm, there's no, who do I
Where
remedy?
does it say that in equity?
Hmm?
Where does it say that in equity?
Equity will not suffer a wrong without a remedy.
Yeah.
If there's no wrong party, there is no requirement for a remedy. End
The
of.
wrong party is society in general by driving a car.
How is society harmed, Nick?
I know that.
You've yourself said
Right, you
and
carry on down
admitted
the way, Mark, and you'll
no
come unstuck.
harm.
You'll come unstuck.
But can I ask a question here? Okay, this business about due care,
Yeah.
right? Does it not remove the fundamental right to self-defence? So,
No.
yes, it does. It does, because if
That's a
I've
law-
got
self-defence is a lawful excuse, though.
that's the point. And you are literally stealing with what you're saying. You're stealing away from me the freedom to make a decision, okay, to use a dangerous vehicle in order to defend myself.
No, no.
Yes, you are.
How am I doing that?
Because you're making it unlawful.
Use reasonable force to defend yourself.
That's the point. So my brakes are failing, okay? I know all the circumstances around it, and I've decided that I need to take that car to the destination, despite the fact that it is dangerous, because I need to do that. That law you're quoting, robs me.
No, it doesn't. Reasonable well-intentioned behaviour is not criminal.
Sorry?
That's a fundamental principle what you need to regard.
Eh?
I said reasonable, prudent, well-intentioned behaviour is not criminal, regardless of any legislation or previous case law, or whether you're a person or an individual or whatever you like. Reasonable, prudent, well-intentioned behaviour is not criminal on the other hand.
Of course it's not.
So if you've got a car with defective brakes and you've got some greater cause, you're allowed to use reasonable force.
Yeah.
That's-
And you've
that's why-
said yourself
that's what
in the
duty
case
of
that
care
you
says.
presented, the
That's
fact
what
that
duty-
you
that's what
presented
duty of
yourself,
care says.
there was no harm
Reasonable
caused.
care,
What's the
which is
problem?
not the injury you know, you've got to balance the probabilities of driving that car with defective brakes against the probability
Could have,
of
would have.
harm caused.
It depends on the circumstances, mate.
Absolutely.
On the balance of probabilities, you can slip and fall and kill yourself when you get out of bed.
Everything's
Everything's possible.
Every case has to be judged on its own merit.
Correct.
Even if it's
And
technically,
you've already presented the facts of your case that no harm was caused.
even if it's technically,
It makes no difference.
You're wrong, Mark.
Well, that's fine, I'm wrong.
punishment is proportional
This
to
is
the
so
harm.
fundamental.
There's no punishment.
Because this is the killing of masculinity.
Yeah, no, I mean, if there's
It
no
is.
harm caused, at the end of the day, who the hell has been harmed, therefore who requires remedy?
Who's making the claim?
You don't have to make a claim to have a criminal offence.
No, criminal offence
Criminal
is merely
offence,
a definition
legislation.
created by
Criminal offence.
by legislation, by those governments.
Legislation.
They create what's a criminal offence. Nobody else decides what's a criminal offence.
Knowingly is the element which makes it criminal.
Yeah, knowingly causing harm is a different thing. Very different.
There's a lot of splitting hairs, you know what I mean?
Yeah. Okay, anyway, we'll talk about that later, right?
Bullshit later.
We can talk about that later. Okay, so if you do not interact, you will end up with a default judgment, provided the other person is willing to take it to public dispute resolution. So, already, when we look at just this bottom end of the structure, okay, you've got the magistrates court, you've got the county court, you've got the family court, you've got the first tier tribunal, you've got the crown court. Okay, so there's 1, 2, 3, 4, 5 different things there already. And that's the bottom level, the entry level of the court system. So magistrates courts have the right and the jurisdiction. Remember yesterday we said jurisdiction is the authority to act, okay, for all criminal matters and all civil matters. So in the first instance, all criminal matters go into the magistrates court. If they're indictable offences, or either or offences covered, is it?
Sorry, bro?
Either way offences, either or.
Overall, yeah.
Okay?
Either way.
They will decide, okay, if it's indictable, they will do the case management, have all the parties got everything, and if it's indictable, it goes then into the Crown Court for trial by jury. And if it's either way offence, basically they'll say, oh, do you want a trial by jury, or you're happy for us to deal with this thing in the magistrates court under these rules? And the county court is civil, and basically you can get civil trial by jury in the county court. The family courts are for family matters, so it's specialised in that. And then you get endless or a huge range of tribunals, employment tribunals, property tribunals, valuation tribunals, you know, there's loads of them, okay? And what they're trying to do here is say, okay, we've got expertise in dealing with disputes of these different natures, and therefore, please put your post in the correct post box, i.e. your claim needs to go into the correct place. So these are the entry-level courts. Now, from the magistrates court, okay, the route of appeal is to the Crown Court first. So anything which biased any party has the right of appeal. A default judgment where you've not engaged, you automatically have the right of appeal. Okay? And if you've engaged and you disagree either on a point of law or a point of fact, i.e. how could rationally that decision have been come to, that is automatic right to appeal. And on criminal matters, because the state is bringing the charges on behalf of the people, then you are entitled to defence costs by the state. On the civil side, it doesn't work like that. You've got to pay to bring your case, and you've got to pay to defend the case. So the tribunals basically go from the tribunal to an upper tribunal. Now the tribunals are new, or relatively new in the structure of courts, and they operate under not very different rules, much more equitable rules. So for instance, in an employment tribunal, I can represent anybody I like, or anybody that chooses me to represent them. I do not need to be part of the legal profession. Okay? So already the changes are occurring with the new court structure. And the same thing is in the county court, they've now made the money claims court for up to £10,000, I think it is, where you can just bring the case yourself. You don't need any legal representative, and you can defend all of the stuff yourself. So it's moving into equity where it becomes fair and just. In tribunals, you've got none of this crap about, you know, the judge sitting up there and, you know, the bench over there and this, that, the other. None of that exists. Tribunals literally can be a room like this, and they've just got some tables. It's a very informal setting. Why? Because at least it removes that stress. It puts the parties on equal parity. Okay? So the system itself is moving into equity, and